كلية الفقه الحنفي تقدم.
Assalamu alaikum wa rahmatullahi wa barakatuh. We are on lesson 12. Welcome to lesson 12. And may Allah subhanahu wa ta'ala bless you all. We're in the middle of the Kitabu Adab al-Qadi. The Qadi has just taken up his post. That's where we got to. And the Qadi is now, has taken over all the registers and all of the documents, and he's trying to figure things out. He's gone and looked at the people who have been remanded in custody to see what their case is and whether there's something that needs to be done with them or not so far. So all of that has happened so far. So now what we have to do is, the next thing that he's going to do is, when he looks at those people, and if any of them are now willing to confess or to do what they're supposed to do, why they've been in prison for, so he goes and gets that all sorted out, and the right of whoever needs whoever needs their rights established will be taken care of, and whoever's among the prisoners or whatever, whoever is still denying their liability, then he can't accept, if the previous judge has a statement about them, that was short of a judgment. He can't accept that anymore, because once a person has been fired or has left his post, he just becomes like any normal person. Their statements that are out of court don't carry any more weight than another regular person. So that person doesn't have influence anymore. That's why you can't take any opinion from him afterwards, except like you would take it from anybody else. Yes, if there's proof, then you'd have to go. This new judge has to go by the proof. That's why it says, فَإِن لَمْ تَقُمْ عَلَيْهِ بَيِّنَةٌ لَمْ يَعْجَلْ بِتَخْلِيَتِهِ حَتَّى يُنَادَى عَلَيْهِ وَيَسْتَظْهِرَ فِي أَمْرِهِ. So this is talking about the existing prisoners, right? So if there is no evidence established against them, clearly they're in there for a particular reason. So now he needs to figure that out, right? So if there's no evidence yet, he can't just quickly free them. He needs to take it easy, make an announcement in public. That means, he says, in the different congregations, in the bazaars, in the markets, etc. Nowadays it'd be in the media, that this is what's going on. Nowadays, I think all of these things will be probably more fully recorded. In those days, they may not have fully recorded everything, or maybe there's some paperwork that went missing or whatever. So he says, وَيَسْتَظْهِرَ فِي أَمْرِهِ. He'll try to find out what his matter was, and then based on that, he will have to take care of it. Then the next thing he says is وَيَنْظُرُ فِي الْوَدَاعِ وَارْتِفَاعِ الْوُقُوفِ فَيَعْمَلُ عَلَى مَا تَقُومُ بِهِ الْبَيِّنَةُ أو يَعْتَرِفُ بِهِ مَنْ هُوَ فِي يَدِهِ. So remember, in those days the judge was also in charge of the various different deposits. So they would have maybe made deposits of maybe assets of that belong to the state or otherwise to different people. So he has to make sure that he's aware of all of them and he's in control of all of them, and if he needs to get the deposit back, he has to get it back. Likewise, it looks like the judge also had the responsibility of dealing with the endowments, right? So the wukuf, so to see if they are income generating endowments, to go and check those out, to make sure that the people who are responsible, that they've appointed, are doing the right thing, and so on. So all of these things he will have to do. So inshallah, that's what we'll be discussing. So I think that there was a possibility maybe that when one judge left and another one took his place, then some of the people who had deposits that they were safekeeping, people who were supposed to run certain functions of the state that the Qadi was in charge of, maybe they might have felt that once that judge goes, there may be some people who have bad intentions, that now we can just take it over, make it ours, or not report, or not give proper accounting, and so on. That's why this judge needs to take all of that into consideration, and wherever the evidence leads him, that's how he needs to act. Or if there's proper paper keeping, proper paper trails and so on, then obviously it'll be a lot easier for him to do his job. Right, now, can he consult the previous judge, well, I guess he could consult him on a private level, but his statement does not provide any additional evidence more than any other normal person. So that's why he's saying وَلَا يَقْبَلُ عَلَيْهِ قَوْلَ الْمَعْزُولِ. He can't just accept a statement of the previous judge, of the judge who's been dismissed, because he's just like anybody else now. He's gone back to being a normal common person. إلا أن يعترف الذي هو في يده أن القاضي المعزول سلمها الودائع أو الغلات إليه. Right. So he has to go and scrutinize all of these different deposits and administrative posts and things like that, because he doesn't want people to be taking advantage and misappropriating these things. So that's why what he would have to do is he would have to go and check all of these things out, and then he would have to so I said he can't take the view of the previous judge and take his statement for a fact. He will have to go and investigate these people, and if these people, they confess or they have that there's evidence, then that's how he's going to have to reinforce their position, or take it away from them and give it to somebody else. So he has to make sure he's on top of things, essentially, right? Now it moves into his process of judgment, right? These were things that he has to do kind of on the side, but his process as a judge, which is taking cases, lawsuits being presented in front of him. Where does he do that? So it says وَيَجْلِسُ الْقَاضِي لِلْحُكْمِ جُلُوسًا ظَاهِرًا فِي الْمَسْجِدِ. He has to be in a public place. Nowadays we actually have courthouses. In those days sometimes they just did this as part of the activities in a mosque. So that's why it says here that the judge will sit for judgment, right, in that specific position. جُلُوسًا ظَاهِرًا, in a very apparent manner, in a very clear-cut matter, in a very evident manner, not in a hidden manner, not in some corner somewhere, but in a way that everybody knows that this is where the judge is, and he's there to take cases in the masjid. And which masjid? There could be multiple masjids in town. ويختار مسجدا في وسط البلد. So try to find one in the center of town that makes life easy, تيسيرا على الناس, to make it easy for people to come there. والمسجد الجامع أولى. However, the so-called Jumu'ah masjid, or the Jami' mosque, right? This is basically the central mosque that everybody is associated with, usually they would have the Jumu'ah prayer only there and not in other smaller places. Nowadays we have Jumu'ah prayers in all masjids, but in those days they would only have the Jumu'ah in like the large mosque, and they would use the other masjids just for local everyday prayers. So that's why he's saying لأنه أشهر, because that's more well known, that it's a central location for people to go to. Usually the masjid in the center is probably going to be the Jami' as well. Like in Baghdad, the main mosque of Baghdad was in the center of the town in Abu Ja'far al-Mansur's time during the Abbasids. Now it says وَلَا يَقْبَلْ. Now the other etiquette that he has to follow, وَلَا يَقْبَلْ. Once you become a judge, you have to be very careful who you take gifts from. وَلَا يَقْبَلُ هَدِيَّةً مِنْ أَحَدٍ. Not allowed to accept gifts from anybody except your close kin. إِلَّا مِنْ ذِي رَحِمٍ مَحْرَمٍ مِّنْهُ. So except your very, very close kin, your blood relatives, close ones, right? أو ممن جرت عادته قبل تقلد القضاء بمهاداته. Or anybody who, you had some kind of acquaintance and friendship with, and they would give you gifts from before. So now that they're not giving it to you because of that. They give it to you every Eid. They give it to you like every time something happens. So it's a business person who gives you every time new stock comes in. If it's like that, then it's fine, because they've been giving it to you from before, and it's not going against any it's not going against any out of the ordinary, rather, right? It can't be seen. It has to be very careful that it's not seen as a bribe of some sort. That's why Hidayah mentions the first one. You can't refuse that kind of a gift usually, because that's silatul rahim. It's tying the knots of kinship. That can't be banned, unless of course you're going to have to make a judgment and they're trying to give you those gifts anew because they want to curry favor with you. Then that's an issue. وَثَانِي لَيْسَ لِلْقَضَاءِ. And the second party that's giving you gifts are those people who used to give it to you before, so they're not giving it to you because of a favorable judgment you might give for them, but it's jaryun ala al-'ada, it's their custom to do it from before. And then he says, وَفِيمَا وَرَاءَ ذَلِكَ يَكُونُ آكِلًا بِقَضَائِهِ. Beyond that, if somebody's giving you gifts, then they're probably trying to give it to you. The judge is going to be seen as basically being paid for judgments that he makes in their favor, right? Such that if one of your close relatives that you're allowed to usually take gifts of, if there is a judgment that is pending against them, you're not allowed to take gifts from them. Likewise, anybody who's customarily providing gifts, like, you know, friends, if they suddenly start increasing in their gift, unless there's a good reason, I guess, for it, right? Unless they start increasing their gift, because then that's also suspicious, right? And again, if they also have, if there is a case against them, then one has to be careful and avoid it as well at that time. Right? Are judges allowed to go to invites for food and for other receptions and things? وَلَا يَحْضُرُ دَعْوَةً إِلَّا أَن تَكُونَ دَعْوَةُ عَامَّةً. They're only allowed to take part in open to all invitations. So the judge can just go as anybody else. It's not a special invite for him along with others, you know. If it's a special invite, they're not allowed to go, because then again that could be seen as greasing somebody's palm, or that can also be seen as a bribe. وَيَشْهَدُ الْجَنَازَةَ. It's just that even if it's not, people are going to see it as that, and then it just creates a whole disarray in the community. So that's why there's some very strict rulings. So as I said, I met that one judge and we stayed with him for a few hours, and I asked him all these questions, and I said, because I remember having read this before and I never had seen it in action. So I asked, do you accept gifts? He says, in this community, it's a very poor community. He says, nobody gives me gifts anyway, right? There is no tradition here of giving gifts. I said, well, if somebody does give, what would you do? So I guess he said that I wouldn't take it. It was a very simple person, right? So then he says, وَيَشْهَدُ الْجَنَازَةَ. He can go and take place in burial and janaza, you know, the whole burial process. وَيَعُودُ الْمَرِيض. And he can go to visit the sick. That's a Muslim right that he can follow. That's not a problem. Then then in the actual case itself, when he's got the two opponents, the two adversaries sitting in front of one another, obviously he has to have both of them there, because there's a discussion that you're not allowed to, you can't make a judgment against an absent person, right? That's a rule. So there has to be, the absent person has to be present, or at least the deputy of this has to be present. Anyway, besides the point, let's just say both are there. وَلَا يُضَيِّفْ أَحَدَ الْخَصْمَيْنِ دُونَ خَصْمِهِ. He's not allowed to give a hospitable invitation, like invite them for a meal, one without the other. He can invite both of them, but he can't invite just one and not the other, because again, there's some bias that could express. The Imam Maidani says that the fact that he said that you're not allowed to invite one and not the other indicates that if you did invite both of them, that would be okay, right? Maybe it's his personal way of trying to make them reconcile or something. Okay, also in the actual gathering, when they're both present, he has to make sure that they're seated equally without any kind of hierarchy between them. Likewise, when he focuses on them, he has to focus on both equally. He can't be showing he can't be paying too much attention to one and not the other, like turning one off and smiling in the other person's face, or indicating towards one, or anything else that can be misconstrued as any kind of favoritism. And of course, favoritism wouldn't be allowed as well. And this doesn't make a difference whether one is wealthy or poor, or it's the father and the son, or it is the Khalifa, it is the leader himself that he has to judge, right? So yeah, you can see all of these laws are very, very clear about. Likewise, moving on, he says, وَلَا يُسَارُ أَحَدَهُمَا وَلَا يُشِيرُ إِلَيْهِ وَلَا يُلَقِّنُهُ حُجَّةً. He's not allowed to whisper, talk confidentially to one, right? of them. He can't indicate and make certain gestures to one of them, right, that show any kind of favor or prompting as such, like positive prompting or something like that. وَلَا يُنَقِّيُ حُجًّا, he can't even prompt them either. He has to let them speak for themselves. He has to let them speak for themselves. He has to kind of be quiet and let them speak and then look at the force of evidence, because he can't lead them to make their evidence better. Like he can't lead one, say, oh, but you meant this or you meant this, to make it better, because he has to go on the force of what he sees. He can't put words in their mouth except the formal words that they have to testify with or present their case with. Likewise, he can't smile at one of them and not the other. For example, he can have a smiling face overall if he wants, but not, and he can't joke around with them. In fact, the joking around, and again, joking, it just means maybe a light-hearted joke may be okay, but you can't joke in a way that diminishes your status, that diminishes the judge's status. لأنه يذهب بمهابة القضاء. In fact, people need to be serious in court. That's why usually courts are very serious places. Even in the West, you see that, right? That's why there can't be any kind of major humor and joking that goes on. Otherwise, it just takes away from the whole serious and somber environment that is required for people to act in a proper way there. Okay, فَإِذَا تَمَّتِ الدَّعْوَةِ, once the lawsuit has come in, claim has been made, وَثَبَتَ الْحَقُّ عِنْدَهُ, and the whole process has taken its course and the right is established by whatever means it was upon one of them. Now, if again this is a bit disjointed, it jumps around in terms of what it details, right? So just keep on track. Now, the person who has the right is usually the claimant, right? It was established for him, the right was established for him that yes, the other person does owe him £1,000 or the land is his, etc. Let's just say that he now says, can you please remand him in custody until he gives me my product, right? Unless he gives me what is due to me. So لم يعجل القاضي بحبسه, the judge can't make a haste in imprisoning him straight away. ولكن أمره بدفع ما ثبت عليه. However, he'll instruct him or order him, command him to pay what is due. Right, that okay, you owe him 1,000, or that deed of that land, sign over to him. He can do that, because imprisonment, remanding in custody, can only be at the consequence of a delay in repayment. The haqq and the right has just been established right now, so give him some time to pay. Give him some time to pay, right? So that's why he's saying that imprisonment can only be in lieu of delay in repayment, dilly-dallying in that, and unnecessarily delaying that. So let's make sure that that is what's happening first. We've just established the right on him, now give him some time to pay. This is all in the scenario that the right became established through confession on part of the defendant. Yes, I do owe him. He made a confession, right? He didn't have to go into the oaths and everything. He just made a confession. Because in that case, then it seems like he's playing ball and he's agreed to pay. That okay, I was mistaken, I felt it was otherwise, or now that the judge has said it, yes, I owe him the money. So especially in that case, it doesn't show that he's delayed, right? I know there could be specific cases where the guy has been delaying and messing around and he knew, but anyway, the point is that the judge can't force him to be in prison or imprisoned for until he gives him some time. بخلاف ما إذا ثبت بالبينة, as opposed to where it was a clear haqq and the person, the claimant, had evidence which he must have showed to the person, because people don't go to court just like that for no reason. They usually have to go to court when everything else has not worked out. So he's probably shown him the evidence and everything, and the guy's still delaying, right? So in that case, it shows that he's delaying and he's just trying to cause hassle to the person he owes the money to, and he just wants to pay later or not pay at all. So in that case, فَإِنَّهُ يَحْبِسُهُ كَمَا ثَبَتْ. So in the case where it's established through evidence, not through confession, right, from the defendant, right, then in that case he has the right to imprison him straight away. لِظُهُورِ الْمَطْلِبِ إِنْكَارِهِ, because by him earlier denying, right, that because remember, before the evidence was presented by the claimant, the defendant was asked, is he correct in his claim, And the guy said no. So then that's when the evidence is presented, because the evidence is not presented until they ask the other person first, just to make life easy, that would you confess to it? If he confesses, then it's done. There's no need for evidence. He's confessed. But this was the case when he rejected that, when he said no, I don't owe him, and then the evidence came in, right? فَإِنْ امْتَنَعَ عَنْ دَفْعِهِ حَبَسَهُ. Now, if let's just say he gave him some time to pay, and he doesn't pay in that suitable amount of time, and if he refuses to pay, حَبَسَهُ. Even if he is using the excuse that he doesn't have the money and he's poor, he will put him in prison until it can be proven that he genuinely is poor. Because what's going to happen when you put somebody in prison like that, then his family is going to need money, and somehow, even if they've been hiding it and suppressing that that he has some wealth somewhere, it's eventually going to have to come out, usually, right? That's what's going to happen. So keep him in there long enough that if he did have the money, he'd be forced to, to bring it up or confess. في كل دين لزمه بدلا عن مال حصل في يده. Now, this is kind of a technical understanding. He said that is only, he can only put him in prison and remand him in custody for those kind of debts that he hasn't paid yet, that he put on himself, the debt that he put on himself in lieu of something that he received. Which means, for example, that the guy purchased something. He purchased the car and he's got a debt of £10,000. So he's got an asset right now, the car, so he can do something with it. Because he might not have the money, obviously, but at least he can sell the car to give the money. Or if it was due to some other, so he says, كَثَمَنِ الْمَبِيعِ, which we just explained as a car, وَبَدَلِ الْقَرَضِ, or it was a loan that he had taken. So if he had taken a loan, then he should have that loan money, or he should have done something with that money that he probably has some assets to do. وَبَدَلِ مُسْتَأْجَرٍ, or he had rented, it was the rental payment he had to make. That means, again, he has something, that he would have had something. لأنه إذا حصل المال في يده ثبت غناه به. Because in all of these cases, we're establishing that he got something in lieu of it, which means that he has some level of asset. Or it could also be something that he took on as a liability based on a contract of some sort, right? Yes, I will pay you, and I signed this contract, kal mahri. The dowry, he married, he got married and said, yeah, I owe you £2,000 dowry. Well, kafala, or he gave a guarantee, he provided a guarantee for someone, right? Because these are voluntary acts. Marriage is a voluntary act. You're not forced into marriage, right? And to pay a mahar, that's a voluntary act to get married. Otherwise, just don't get married yet. Likewise, to provide provide guaranteeship to somebody, that I'm being his guarantor, that's all voluntary. And people don't do those kind of voluntary things if they don't have the capability. So all of this demonstrates that he has capability, but he's still not paying, which means that you can put him to prison until you can prove it, right? That he's not. Right? Okay, aside from these kind of cases, in anything else where the penalty is on him for something that he did not take on, right? It could be a penalty for driving fast, it could be a penalty for, accidentally breaking somebody's property, right, or something. وَلَا يَحْبِسُهُ فِي مَا سِوَى ذَلِكَ. He can't imprison him for other than that, because if he's saying he's poor, then he probably is poor. Okay, but of course they'll keep watch, and his creditor will keep watch, and if they find that he's actually, mashallah, spending money here and there, and going normal day-to-day life, he seems to have money, then that would be a different case. Like badalu khul'in, he did khula with his wife, right? Or she did khula with her husband. Now that's not something that she got a benefit for, so she has to pay the khula, right? She didn't get anything in lieu of it except a divorce, but it was not monetary. Likewise, maghsoob or mutlaf, he or she had damaged something or usurped something, inappropriated somebody's property, and the guy, and then it got destroyed. So you can't even, because usually in inappropriation you have to give back whatever you've inappropriated, but in cases where it's been destroyed or consumed, you can't give it back. So then you owe the money. So he's got nothing to show for that, right? That's what he's saying. Now, all of this is if he says, إِذَا قَالَ إِنِّي فَقِيرٌ, that I am a pauper, I am poor, I am in need. And he's going by the original, because people aren't born wealthy, they're born poor, they're born without any assets, they have to gain assets, so he's on the default status, right? إِلَّا أَن يُثْبِتَ غَرِيمُهُ أَنَّ لَهُ مَالٍ. Yes, his creditor does have the opportunity to prove that now the guy's got assets. How do I know? Well, look, these are his friends, they're proof, they've told me he's got assets. Or he's got these cars that are parked on the next street, right, at his brother's parking lot. So if he can prove that way, then in that case, if he still refuses to pay off, right? Because some people, what they do is they refuse to pay off. They don't have a plan to pay off. Say, oh, when I sell this, when I sell that, but they got no plan to sell their assets to pay off. So the judge has to make sure that all of that happens. So in that case, فَيَحْبِسُهُ حِينَئِذٍ شَهْرَيْنِ أَوْ ثَلَاثَ. So as we will discuss, he can then imprison him in that case for 2 or 3 months. He says that yes, in that kind of a case, because now you can see that he's delaying, he's got assets, but he's actually lying and telling an untruth that he doesn't have any assets, and he's been proven he does, then he can keep him in prison for 2 or 3 months. 2 or 3 months is not fixed. It could be less, it could be more. It just depends on what the judge thinks of how long it's going to take for this person to learn a lesson and start paying, right? This is all the judge has a right to do that, and it's also enough time that if he does have the wealth, then he would, he would have to reveal it by now. So that's why the Hidayah says that the sound opinion is that the discretion for this is left to the judge, because everybody's situation is different. The other thing, let's just say that the person says he's poor and he lets him go, then the judge, what he can do is, the judge has to make an inquiry to ascertain whether he's really poor or not. Because then if he's poor, then he's given more time, right? Because ultimately he can pay. ثُمَّ يَسْأَلُ عَنْهُ جِيرَانَهُ وَأَقَارِبَهُ وَمَنْ لَهُ خِبْرَةٌ بِهِ. The judge will then go and start asking his neighbors. The judge doesn't have to go knocking on their doors himself. He can send his guys, he can send his workers, the people who work in the court. He can ask his relatives, and he can ask other people who may know of him, like business acquaintances and associates. فَإِن لَمْ تَظْهَرْ لَهُ مَالٍ. So if it does become clear that actually he doesn't have, he lost it all, right, or he just didn't have it from before, and there's a reasonable picture that emerges about this, خَلَّى سَبِيلَهُ, he can let him go. Because just like anybody else, the Prophet ﷺ has mentioned that people with debts should be given opportunity, should be given time to pay for when they can conveniently pay, which is called al-nadhira ila al-maysara, right, to essentially postpone it to when they're able to pay. So if the Qadi then insisted, or his creditor insisted then on him being imprisoned, then that's going to be counterproductive. It's going to be actually oppressing this person now, because he can't make any money if he's inside either. Although some people are so lazy, they probably get free meals there, and they won't pay, and they want to pay. But anyway, this is the normal case. So what the commentator is then saying is that the judge can't accept any proof until he makes his own inquiry, because the guy may have proof that he's willing to provide witnesses that he is poor, and again, that could be made up. So in this case, it says that the judge has to actually make his own inquiry first before he accepts anything like that, right? And then there's some detail about exactly when. So then Qadi Khan, he says that if he establishes if he established that he's proof, witnesses that he's bankrupt before he gets imprisoned, then there are 2 opinions in that regard. Ibn al-Fadl says the sahih and sound opinion is that, okay, accept it, but it's better that be left to the discretion of the judge, because if the judge sees that this guy is a shameless guy who's just purposely delaying and not trying to even get money to pay off, he's just lazing around, he's a loser in that sense, then don't accept his evidence in before he is imprisoned. Don't accept it, but rather go and make your own inquiry to find out if that's the case. And if he finds out that no, he's a soft guy, he's a decent guy, then accept it and don't imprison him right from the beginning, right? In the Nahr and Khania, said this is left to discretion. That's why in An-Nahr al-Fa'iq, transmitting or quoting Khaniya, he says that if his poverty is well known, like it's quite apparent, everybody knows that he works hand to mouth, etc., then he can quickly ask, just make a cursory investigation and then accept him and then let him go so that he can go and do something for himself. Right, now the judge isn't allowed to, he might have let him go, but the judge then is not allowed to place a barrier or a restriction or a restraining order on the creditor from him. Right, the creditor has a right, that this guy has to produce, so he can stay with him and chase him, and what they call mulazama in Arabic, like he can stick with him essentially to make sure that he pays, so that he knows that he better make some money quickly. So the judge is not allowed to place any kind of restraining order in that when the guy is not in prison, obviously, right? However, the people aren't allowed to go into his house. His creditors aren't allowed to go into his house. They can stand outside. They can literally stand outside 24 hours a day. That when he comes out, they can pester him. Okay, where's our money? So to kind of pressure him and force him. Right. Some other cases. What about if the debtor is a woman and it's a man who's the creditor? Can he chase her like that? That's seen as not very good, although some scholars do allow that even, right, to happen. But in this case, Imam Maidani is saying that rather he should appoint a woman to do that for him, because that's a very compromising situation. So that might get him in trouble eventually. She might accuse him and so on, I think, So get a woman to chase her instead, and to stay with her and to basically be with her all the time until she pays. Nowadays, I mean, there's other ways to do this. They get into your bank account, and there's other ways that they would recover, because everything is online and other people have control over it and so on. So this is a time when there were no banks and people just look after their own assets. Right, he then says, these are now a discussion of other people that can be imprisoned or not, right? So وَيُحْبَسُ الرَّجُلُ فِي نَفَقَةِ زَوْجَتِهِ لِظُلْمِهِ بِامْتِنَاعِهِ. A wife puts in a case that my husband doesn't give me my monthly stipend, for the basic food and drink and so on, right? And clothing and so on. So the guy refuses, so they can imprison him every month until he pays. What about a father so anybody can be imprisoned for anybody else if they don't pay, and it's established in the way we said and the procedure is followed. However, a father can never be imprisoned for a debt owed to his son, right? Because remember, imprisonment is like a punishment, and a child will never have a right like that upon the father to impose on him. It's just a special relationship that doesn't allow that right to be established. Except in the case where it's not an older son, it's a younger son, and the father is responsible for their expense as well, just like he is for the wife, and he's refusing to do so, and they're struggling big time. So that way they're going to perish. They're going to be severely malnourished or damaged, or in big trouble, essentially, in big pain and hunger and so on. So in that case he can do that, and also because this is a technical issue that the wife and other expenses, once the month passed, that expense it passed, it can't be rolled over as such. Then it's the new months. It's the new months. The only time it can be rolled over is if there was a judgment from a judge that yes, you have to pay this much, or they had a mutual agreement that he has to pay this much. That's a separate issue that you will learn in nikah, right? And then وَيَجُوزُ قَضَاءُ إِلَّا إِذَا امْتَنَعَ. Yeah, we did that. وَيَجُوزُ قَضَاءُ الْمَرْأَةِ فِي كُلِّ شَيْءٍ إِلَّا فِي الْحُدُودِ وَالْقِصَاصِ اعْتِبَارًا بِشَهَادَتِهَا. This is a very straightforward statement. It's just a one-liner, essentially saying that the judgment of a woman is permitted in everything, except in hudud and qisas. In hudud and qisas, they won't be. This is if she was made a judge and she judged in accordance with the deen, then yes, that judgment would still be a valid judgment, right? Just the same as, because remember, to be a judge, the conditions are that you can also bear witness and be a witness. So a woman can be a witness as well. So in that sense, her judgeship will be valid. Now I have to differentiate between validity and permissibility. So according to many of the texts that I will read for you, it shows discouragement and reprehensibility, in a sense, dislike for women becoming judges. But if they did become a judge and they also ruled correctly, then there's nothing stopping that judgment from being a valid judgment, an official judgment, just like if a man had done so. That's essentially what they're saying, right? So there's opinions from different fuqaha regarding this, which I will talk about and then finalize, inshallah, in the conclusion that we have today. Conclude for today, I'm not going to go into any kind of exhaust treatment of this issue of can women become judges or not, right? I'm just going to quote to you what the editor here, which is Sa'id Bakdash, in his copy, in his edition of the Lubab, which is a commentary of the Quduri, he says that Ibn Abidin says that they have differed with regards to women becoming a judge in everything other than hudud and qisas. So those kind of, you can say, strict, severe punishments for drinking, etc., and qisas, which is retaliation for a limb or life, right? Aside from that, those are, everybody's agreed that they're not allowed to be a judge for that, but in everything else, there's a difference of opinion. Then the Haskafi mentions in Ad-Durr al-Mukhtar that وَالْمَرْأَةُ تَقْضِي فِي غَيْرِ حَدٍّ وَقَوَدٍ, that a woman provides judgment in other than had and qawad, which essentially refers to the qisas and so on. I said وَإِنْ أَثِمَ الْمُوَلَّى لَهَا, or مُوَلِّي لَهَا, sorry, except that the one who put her in that position and appointed her to that place will be sinful, right? So there's a sin in doing that, but then if she gives the judgment, it will be valid, right? Essentially saying that. Why? Because there's a hadith of Bukhari which he invokes. The Prophet ﷺ said, لَنْ يُفْلِحَ قَوْمٌ وَلَّوْ أَمْرَهُمْ إِمْرَأَةً. No people can be successful, no community, no people can be successful who have consigned their matters to a woman, right? And that's why Razi in his Khulasatul Dalail, which is another text, has explicitly stated that it's makruh for her to do these others, it's makruh, it's disliked for her to make judgments in other than hudud, right? That doesn't mean that it won't be implementable, it's just that it's makruh, it's sinful in that sense, right? Ibn al-Humam has an interesting take. He says that the discussion here is if she was appointed and the appointer, whoever put her in that position, has already been sinful for that, and then after that she made a judgment that was in conformance to the judgment, then would that be, he's asking the question that if all of that did happen and then she made a judgment which was in conformance to what another judge would have made, and according to Sharia, would that be implementable or not? So that's the question. So he's saying that we can't see any evidence, to cut it short, essentially summarize, he's saying I can't see any evidence to say that after it being in conformance to what Allah subhanahu wa ta'ala revealed, that unless somebody wants to go as far as saying that she absolutely has no capacity to be a judge at all, like completely, unless somebody's willing to claim that extreme position, then yeah, because the Sharia on the other hand has just mentioned that she has deficiency in her intellect, which as I explained before, my opinion on that is that it's because of her emotional state usually, right? So, and then he says that statement is referring to women as a whole, like women as a genus. That doesn't mean that every single woman, right, 100%. There could be that 95% of women are what the Prophet ﷺ has stated, and then it could be a few, as we have also seen, that are not of that same level of deficiency, and they have more, they have similar traits to, masculine traits in that sense, or this they can make a judgment in that sense. So he's saying that we can't necessarily say that that is not going to be implementable, right? So he says, لماذا يبطل ذلك الحق? Why would we allow that right to be wasted if a woman gave that judgment and she was already in that position? After having said that, it was makruh to put her in that position in the first place anyway, right? So Jazakallah khair, that's the end of our 11th lesson, in actually our 12th lesson, sorry. And we will carry on inshallah in the next session. We have some parts left of the Adab al-Qadiyat. Assalamu alaikum, Allah bless you all. Assalamu alaikum.